Let's talk about labor issues because in just about 2 weeks, Ghanaian workers will join their counterparts across the globe to celebrate Labor Day, a day set aside by the International Labour Organization to recognize the important contribution being made by workers as well as issues militating against their welfare. Now, ahead of that, pulse will begin a build-up with interviews and special features on this very important issue, and the focus is on the employment relationship today. Joining me in studio is private legal practitioner Ekua Kun. Okay, yes. I hope I got it right.
You got it right.
Ekua Kun.
Yes.
Okay, Igwa Infanifi.
In actual fact, me fegwa me fi sekunde.
Oh, sekunde mo. Also ni fi sekunde ifa.
Okay, if you back you
oh, if you correct one there. Anyway, but let's first of all look at this. When do we say there is a worker and employer relationship?
Okay, so we say there's a worker and there is an employment relationship where you have an employer and an employee who have contracted. The employer has contracted the employee for their services to work for them within under a contractual relationship.
Okay.
So you may have an employer who would engage someone. It's called a contract of services for their services for compensation. So let's say the worker would offer their services, and then there will be compensation for their services.
Okay.
There's a difference between a worker who is fully engaged and an independent contractor. And the level or the difference between the two is determined by the extent of control that the employer has over the worker. That if, of course, it's an independent contractor who has come into work, you don't have any control per se because they've just come in. So it's got to do with the extent of control. And then who bears the risk, assuming anything goes wrong? So assuming you're in here, I believe you're all workers of Joy FM. Your relationship with your employer is different from an independent contractor who comes in, let's say, on a contract basis to just offer or paint or do anything. So one, the extent of control, because once you're in here, your employer can decide, I mean, whatever arrangement, how you're supposed to work and all that, your level of hours of work and all of those. And then also the risk, assuming anything happens to you whilst you're working here, who bears the risk? Of course, the employer. And then also got to do with what you call vicarious liability. And the law, when you say vicarious liability, it means that assuming anything happens, you, whilst in the course of your work, you cause injury to anything, who bears the risk? Again, it will be the employer, because anything you're doing whilst you're working is being done with their authority or under them. So they bear all those. So
that includes when I am coming to work and going after work?
That is very subjective. Assuming you're coming, that's a tricky one. Okay, assuming you're coming into work, you've not started working yet. Your working hours are 8 to 5. Anything that happens outside those hours, of course, you're on your own. But anything that happens within the 8 to 5 period, for instance, you've been tasked to, let's say, go and cover a program. On the way, if anything happens to you, who bears the responsibility? It's your employer, because within that period, you're still working. Yes.
Okay.
And then, of course, things like tax purposes and all those help to determine who an employer, that employment relationship.
Okay.
Yes.
So it means that if I should hire a mason to do a by day for me, the same conditions will not apply to when I am.
Because they are independent contractors who are working, whom you have contracted for their services. Now the difference, it's very tricky. If you're an employee, you're working, it's your contract of your services. But when you're an independent contractor, you're contracted for your services. So the difference is off and for. So that when let's say an independent contractor comes in, one, he's not I don't think there's any serious contractual relationship. When he comes in, you know, he can just decide to walk out because he's not regulated. Whatever happens here, he's on his own. He bears his own risk and all of those. So those are the determining factors. I think when he comes in, he would even rather be the one to tell the Joy FM management that I can finish this job within this period. It's not for the employer to determine. But whereas you come in, the employer would say that you are supposed to be working 8 to 5. But human is an independent person who is just coming to, he would even determine his own, perhaps hours of work. I mean, what times he would come in and all of those. So those are the difference.
Okay.
And then, you know, of course, things like pension and all of those also comes into play. So
it comes into play when a contract. It doesn't matter the contract. It doesn't affect
For
the contract.
For instance, once you're working, there are laws that regulate what has to be done. So if one of them, like I said, because it's contractual, once you're working, things like remuneration, your SNED and all of those determine whether you're a worker or an independent person who has just come in.
So the independent person will not be covered by this SNED and all of that. It won't happen. How do we build the employment relationship, you know, such that there will be that? First of all, we know there has to be cordiality between the employer and the employee, but we get to a point when you realize that the cordiality is not there. How do we build it?
Now, you realize before we had the legal regime, you had situations where there was so much unrest because, of course, sometimes you have a situation, I think sometimes between the employer and employee, the bargaining power is not equal. One is a bit there and the other. So sometimes you have situations where workers or employees feel they are not being treated so well. So there's things like issues like labor unrest and all that. So that is where you have the legal regime coming in, where laws are enacted to regulate the relationship. So although, yes, you have the employer who has employed you, laws will regulate how the relationship should run. So you don't have, so there's cordiality, there's harmonious working relationship and all of those, in Ghana, I mean, there are several laws that regulates the employment relationship. We have the constitution that regulates. For instance, you go to Article 24, it states, I mean, the rights of the worker. And then you have other laws. We have the Labor Act that actually regulates the relationship. You have the SNIT, I mean, the Pensions Act. You have Factory and Workers, Act. You have various laws. I mean, workmen's compensation that will regulate. For instance, assuming you're working and then you're injured in the course of work, that regulates or it determines what kind of compensation. Either you're seriously injured or you become disabled, or maybe death arises out of the injury, what perhaps you are entitled or your family is entitled to. And then there are quite a few laws. But the main one is the Labor Act 2003. 2003. Yeah.
So with the compensation, if still you work outside your work hours and anything happens to you, that does not fall on your employer.
It doesn't fall.
Okay.
Because you're on a frolic on your own. So you're otherwise it widens it, and of course, I mean, these are insurance matters, and also if you're on your own and the employer is supposed to be responsible for that, then they would open a floodgate. In that there will be so many, and it could, cause problems for the employer as well.
Usually, like you said earlier, when it comes to bargaining, the employer is up there and the employee is quite, down there. What happens when an employee finds out that his statutory payments are not, being followed through by the employer? Taking into cognizance the fact that you still have to maintain that cordiality in terms of the employment relationship.
One, it depends on the kind of environment in which you are. Some organizations have what you call trade unions, all of that assisting. Because, for instance, maybe as a single worker, sometimes you cannot fight. So in some organizations, workers are allowed to form unions so that with one voice they can actually ensure. So you have what you call collective agreements that regulate. So even by the time you are coming, there's already a collective agreement that determines what the employer is supposed to do. Then you have, like the labor commissions. Within the Labor Act, you have a labor commission that is supposed to, determine or mediate or arbitrate on some of these matters. Of course, if your employer is not also paying, you have the opportunity to, if you want to, you can, report the matter as well to the various authorities for redress.
Okay.
Yes.
So,
but then, of course, you can have discussions with your employer for maybe there may be reasons. So, when there's a harmonious working relationship, then there's a room for dialogue, where although you have the employer there, there's room for negotiations between the employer and then the employees, so that it makes it more harmonious and a congenial place to work. Yeah.
In your years of practice,
Yes.
how extensive is this practice of some employers deliberately, underpaying or not even not paying statutory payment like SNED contribution and income tax and all of that?
Any employment relationship that is over 6 months, that extends beyond 6 months, there must definitely be, that's what the Labor Act say, that there must be a document. So if someone is going to engage you and is not temporary, less than 6 months, and it travels beyond what you should be asking for is like a contract of employment or whatever document there is. And in there, you should study to find out what are your entitlements in there. So, if they're not paying, then like I'm saying, if there's an HR, you should find out why they're not paying, and you should ensure, that they do.
So how widespread is this? You've been in the sector for some time.
Yes, all the laws are there. There's a Pensions Act, all the laws are there. It's just that sometimes the enforcement. But then that's why we're actually doing this, because sometimes you may have instances where, of course, people set up, but they don't even know what they are obligated to do. So they may set up an organization and say, this is what I want to do, especially within the informal sectors that they set up. And so all I know is that at the end of the day, I'm even paying you off the desk or table. It just puts money in an envelope and that's it. But once you engage someone and it's a permanent work, it's not just the remuneration, but the employer is supposed to be paying various other entitlements like your SNIT. You're supposed to have certain entitlements as well. And then SNIT is a requirement once you're working. It is. It's not. It's compulsory actually. Yes.
How do we ensure that some employers are not exploiting the unemployment situation of Ghana to then employ people without even employment contract? Like you said, if it's beyond 6 months, you should be given employment. But we are in Ghana, we know people who are employed without contract at all. So
you could actually take the matter up at the Labor Commission. Sometimes people are a bit, we have workers who are a bit hesitant in going to some of these institutions, but sometimes it may be because they think, they may not even know. So sometimes, one, you should, take steps to ensure that they do what is right. When you have an employer who is not doing what is right, I think that it behoves on you to ensure that you, take you to the right, institutions to ensure that what they have to do, they actually do it. For instance, when you go into the Labor Act, there are rights and responsibilities for both the employer and the employee. When you go to Section 8, it has all the rights. We have all the rights of the employer. Section 9, is provisions on their responsibilities. And then you go to 10, the responsibilities, the rights of the worker. And then you go to 11, it states their responsibilities. So at least in there, you know that as contracting parties, we have the law stipulates what each party is supposed to do and not supposed to do.
Okay.
For assuming, for instance, you go to Section 8, one, because he's the employer, he has the right to set up, and he has the right to cease operations anyway. So once the law allows anyone to set up a business, if business is not running, they can decide to cease operations. For instance, they can determine the policies they want to regulate or guide how the business must run. They have the right to discipline because it's their institution, it's their firm, or it's their business. So they have the right to instill discipline, enforce discipline, and then, and determine how the operation should run and all of that.
Okay.
They're allowed to do that. When it comes to their responsibilities, one of them is ensure that, of course, they are supposed to pay you the contracted pay that they have told you, or wages or salaries that they have told you they would do. They are supposed to ensure that you're working in a safe environment, because if you are coming and it's relatively safe in here, because the employer is supposed to ensure that once you walk through these doors, you're safe from injury and all of that, because they should make sure it's safe. So you didn't come in and find spills all over where there's a possibility that you may trip or slip and fall and all of that. What other? Pay remuneration. They're supposed to ensure that it's a safe place, like I said, and various others. Yeah.
When can an employee decide that, well, I think I need to go for a renegotiation of my contract? At what point within the contract can an employee decide to go for that renegotiation?
When you go, when there's a contract, contracts are always fixed, unless it stays in there that there's a possibility of renegotiation. For instance, even assuming outside the employment relationship, contracts are supposed to be fixed. You get me? Unless it stays in there. So within the period, the determined period, it's fixed. That gives you certainty. That gives you certainty and comfort that no one will shift the goalpost. So assuming you're going in there and you have a contract that says that, okay, you've been employed to do this work for this number of duration. These are your job descriptions. You'll be paid this salary. These are your working hours. I think that you expect that everyone will respect what is in there, because a document is sacrosanct. So if it stays in there that maybe in the course of the working period, if, for instance, there's a possibility of promotion and all of those, then of course, then that is where you may call for negotiation, because perhaps your work is being changed. Okay. You're changing your working rules. So then there may be further negotiation, let's say on salaries and all. But then everyone comes into Joy FM and you expect, for instance, that there's equal treatment for everybody so long as you're a worker. One may change, maybe wages or remuneration because of the level of work or the quantum of work you're doing, or the volume or the level of responsibility you have in there. But I don't think that a junior staff will think that, okay, because they're junior staff, they're going to be treated differently, because you're all in here as workers. Okay. So you don't expect that to change unless there's a change of circumstances. You may, for instance, change where maybe operations change, or the employer is, for instance, you go into an organization or a firm or a business, and at some point they moving into a completely different operations that is different from what you initially came into. Then those are the circumstances where maybe there will be the need for renegotiation. But then that means that the previous one would end. The previous
one would
end
for the new one to take over. But do I get an understanding that if say you've been employed to do job A, it hasn't changed, you're still on job A.
Yes.
And if it's 10 years, you'll still be on the same level, same salary, no increment whatsoever.
But then you expect your salary, everyone expects progression, right? So when you come in, let's say at the most basic junior level, the employer is supposed to help you with training. One of their duties is ensure that you don't remain static. They're supposed to train and retrain you, provide you with the necessary tools to make you work. Of course, we all grow. We all grow physically, and we must grow in the work environment as well. So if you have an employer where you see that there's no career progression, there's no opportunity, then of course, I mean, you may want to take your own decisions, whether it's a place you want to be. So you expect, at some point, you may want to have discussions with your employer, because in there, you expect that there should be some progression in your career and all that. So those are things that you can have discussions on.
Okay.
And then you agree. So it's a contract. So one person cannot start negotiation. It's for the two parties
That is to agree.
To agree.
What role does unionism play in ensuring this, employment relationship we're talking about?
Yes, union, like I mentioned, because sometimes in an employment relationship, the bargaining power is not equal. Of course, the employer is always there. So sometimes it's an individual employee, it's very difficult for you to go and negotiate. I mean, in our parlance, even sometimes, even sometimes your own supervisor, you're a bit, you find it very difficult, like a manager,
to approach him.
To approach the person. So it makes it easier when there's a collective force that can come together as one voice to negotiate with the employer, because the employer is there and you were there. I mean, it's difficult because sometimes when you try negotiating, there's a possibility of, dismissals, or you being, I'll use the word, I won't use the word, I don't want to use the word victimized, but the possibility of you have this feeling of, oh, if I go opening my mouth too much, I can get into trouble. So it's easier to have. So the Labor Act allows unionization where, collectively workers can come together and then unionize and speak with one voice and to negotiate with the employer for better, employment benefits and all that.
There has been instances when we've had companies trying to prevent their workers from unionizing.
They're not. They're not supposed to do that.
Exactly. What's the position of the law on it? If they're not.
You see, it's even unlawful for them to prevent, and then they cannot victimize or take decision, or you cannot be victimized for trying to unionize. I mean, it does usually happen in most of the time in private organizations where, so it gets very difficult. But the law allows and permits unionization.
I asked this question because I know of I'm not going to mention the name, but I know a company in Takrady that prevented the workers from unionizing, and those who led for the workers to unionize were unfairly treated along the line. Yes.
Yes. So
if it happens like that, what kind of remedy do these people have?
Like I said, the institution or the body that has been created to determine some of these things is the National Labour Commission. So some of these things you can seek redress at the National Labour Commission, and if you're being unfairly treated just because you're trying to unionize, then of course the employer can be taken up. But then mind you, when it comes, because of the freedom, we're all free. Sometimes there's a backlash also, because under there's precedent that says that, we are free people, and an organization is seen as also an entity on its own. So sometimes when you try to unionize, I've seen a few of these, so that you take them on, and then the next thing you know, they start dismissing or terminating people's employment under other,
provisions of the law.
Provisions of the law, because the law allows, because you're contracting parties, an employer can actually terminate you without any reason.
Okay, interesting.
Yes.
And not pay not pay severance.
And the reason is because you can walk up to the employer today and tender in your resignation. So once you can do that, they also allow.
No, but the law says you need to give them
provided a notice period is given.
Exactly.
But then even the law says that they can terminate, when you go to section 17, for instance, they can terminate by giving notice or payment in lieu of notice.
Exactly.
So for instance, you're there one day and you're just giving a letter. So instead of, for instance, you're entitled to 1 month notice or 3 months. And then what they'll just simply say is that we're paying you the 3 months in lieu. So it's a bit...
Is that different from the severance package anyway?
You're supposed to pay the severance package and all other entitlements that are due you prior to your employment being terminated are supposed to be paid to you.
Okay. Lawyer, I'm sure once we discuss all of this, all these will come up. So I'm grateful that you could join us on the first edition.
Thank you very much.
Thank you so much. Lawyer Egwakun. Your name is so sweet. Fancy. All right, so thanks. This is still the pause, but